myself something of a fat cat. That is to say, on the fattish end of the spectrum, which starts with the self-satisfied and overpaid and ends with the hungry young lawyer thirsting for justice, to whom we appeal. But I would just like to say, it led the season of atonement. It is an honour for me to be called on to put the case for legal aid and to put aside my manifold failures in that respect. The three charges which I'd like briefly to address in defence of legal aid are these. Firstly, it's said that our legal aid system is too expensive, and you've already heard that it's said it costs less in France, it costs less in Germany. What about a public defender system such as they have in the United States? But I think we must deal with that first. The public defender system, such as they have in the United States, it is generally recognised to be a complete fiasco for defendants, in which the hard-pressed and undefended public defenders, both at state and federal level, are forced to extract pleas in a plea bargaining system because they simply cannot afford to take cases to trial. That's what happens when you start cutting corners and start saying that cost must come before justice. The same criticism of the attempt to make an analogy between ourselves and France, as June has already made, I would make. That is to say, it is not a system with an adversarial approach. It is not a system in which lawyers are there to harry, to question, to go out and investigate, whether it be investigating evidence for trial or investigating evidence for the plea to keep someone out of prison for the first time, which is invaluable and can't be done on a fixed fee. It is not that kind of system. It is a system where really the defence lawyer is a mere spectator as the judge and the prosecutor, the juge district and the prosecutor, carve the matter up. And so let us get rid of those analogies. Let us remember that our system is recognised by Carter to be the best system, and not get rid of it, but strive to improve it. A system in which lawyers really do try to question the state, try to question the evidence, and get in there at the start investigating and seeking out evidence for their client. The second allegation that's made is that legal aid is too often misdirected towards the unsavoury and the undeserving. And we all know that the certain types of press get great pleasure in branding, why was legal aid given to this prisoner, or to this loony, or to this scrounger, or to this asylum seeker, or whatever it may be. But what they ignore is, throughout the country, the work that is being done on legal aid for the homeless, which involves timely investigation by lawyers, which again can't be done on the flat fees. In immigration cases, again, it requires enormous work to investigate and find out and present the evidence. It ignores also something more fundamental, which is a principle of justice that has to apply to the unpopular, to those who are on the margins, to those who the media don't like. And that is the principle of access to justice for all. And without that, we lose something which is crucial to our society. And where there is no access to lawyers, there is always abuse. You could see it in the mental hospitals before there was access to lawyers. When there wasn't mental health review tribunal lawyers going in, we had the Rampton type of cruelty because there was no access. You have it in prisons when you don't have access to lawyers, and lawyers have got to be paid to go in and to investigate these matters, to take instructions. And you have it in the wider world. There were no legal aid lawyers in Bagram or Abu Ghraib, and there weren't at the start in Guantanamo. And that's what happens. When you deny access to lawyers, to vulnerable or endangered people, then that's what happens. And the second fundamental principle is the principle of equality of arms. And that really does mean that there can't be a system in which you can buy justice, in which by being wealthier you can be at an advantage in the justice system. There has to be a concept, a striving for the idea that everybody, however poor, however disadvantaged they are, however incoherent they are, should have the same quality of service, the best quality of service, provided for them. And that is the second principle which we must fight for, and which is endangered by the Carter provisions. The third attack that's made is the claim that the legal aid system is inefficient, and that there are too many legal aid firms, too many firms of solicitors, too many small high street firms, hence the idea of the cull, which is envisioned by the Carter reforms. He says 400, the Law Society estimates that 800 legal aid firms will go to the war under these provisions. Hence the idea of competitive tendering, in which people bid for who can provide the cheapest service at the magistrates' courts and at other courts. And there is a real danger in that idea, and it's simply incorrect to say that the small high street firms should be sacrificed and should go with the cull. If you look back over the last decades at the history of the big strides that have been taken, whether in exposing miscarriages of justice, whether in the coroner's courts, in homelessness cases, mental health cases, you see time and time again small high street firms, one-man practitioners, one-woman practitioners, making a difference up and down the country. One thinks of cases in the old days, in the Irish cases, there was Alistair Logan representing people in Guildford and then going in and representing the prisoners and taking those cases. He wouldn't survive in the cull now because it would be said that it's inefficient. There aren't loads of people, paralegals at his beck and call. Look at the Leicester solicitor who took the case of Stanley Johnson all the way from Rampton to Strasbourg on his own, but with the help of, obviously, of counsel. That sort of thing, that local service going in and then taking the case on, that is endangered. So too are firms like Taylor Nicol, where Jim Nicol took the case of the Bridgewater Four all the way along, as Mike's referred to and knows about. Those firms are endangered. Jim Nicol actually said to me this morning, I don't know how we're going to survive. Now, what is the net effect of all this? And the small firms that took the cases fighting for anonymity, in the case of Maxine Carr, fighting for anonymity in the case of Mary Bell. Small local firms that were dedicated to their clients and followed them through the years and took up their cases. They are inspirational, but they are also in danger. And we say that this is what we must fight to ensure that we don't just have a system in which the highest bidder takes all and the small firms and the local provision is endangered. And if that happens, who will suffer? The answer is that the people who will suffer are the people who require time, who perhaps are difficult, the people in the Guardian article today who arrive in the homelessness cases with big plastic bags asking for their case to be looked at, and the person says, oh my God, I can't do that on a flat fee, I'm terribly sorry, I just have to advise you, you've got no case, take the flat fee. That is the danger. And the danger is that people will be deterred from taking those important cases, from taking those groundbreaking cases which do actually improve society. And so I would suggest that we must back legal aid, we must support it, we must fight for it, and we must fight against those aspects of the cut which endanger that. Not every aspect, but those aspects which endanger it. And if we don't, then there is a danger that the people who will suffer are the most vulnerable, the most marginalised, and those actually most in need. So, I invite you to acquit legal aid, to unite together, and to fight these cuts barristers, young solicitors, young barristers, all of us, even the fat cats will join in this battle, and we will fight. We'll fight them in the courtrooms. We will fight them in the high streets. We will fight them in the press. We will fight them in Parliament.